Welcome back. It's the big story this hour. The Electoral Court describing the ANC's explanation for why it belatedly brought the review application against the MK party in court as irrational. The court says the party's explanation does not come close to justifying the delay in instituting legal proceedings. This, of course, is in relation to the ANC's bid to try to get the MK party deregistered ahead of the 29th of May. That's when South Africa heads to the polls. Let's continue with our reaction now. Terry Tselane is the executive chair of the Institute of Election Management Services in Africa, and in fact worked as a former vice chair of the Independent Electoral Commission. And he joins us now via our video link for his take of what's happened. Terry Tselane, always great speaking to you. Thank you very much indeed for making time. The court, depending who you ask, really scathing of the ANC on three major fronts. The one around the delay, the second around jurisdiction in this matter, and the third when it comes to the merits. I'm hoping to engage you just on this third issue, this idea that the Deputy Chief Electoral Officer, Mawethu Mosri, erred, according to the ANC, in allowing the MK party to register using a supplemented application. The court here has found that there was nothing wrong that the DCO did. And I wonder whether or not you reckon they've said enough about ways in which the legislation can prevent a repeat of this, essentially.
Good morning. Of course, the submission of the African National Congress looked uncoordinated, very disorganized. If you take in consideration that at the beginning, the issue that was in contention was about the trademark and the ownership of MK. And that's how they submitted the issue when they raised it with the commission for the first time. But when they went to the Electoral Court, they completely abandoned that and only focused on procedural issues in terms of the registration. And I think to a large extent, when it comes to the issue of the procedure that was followed by the Chief Electoral Officer or Deputy Chief Electoral Officer, there was absolutely nothing untoward in terms of the way the party was registered. Because the issue of how or what information they get in order to be able to satisfy the provisions of Section 15 of the Electoral Commission Act is really the discretion of the Chief Electoral Officer or Deputy Chief Electoral Officer in this case. So what the Electoral Court has done is basically to affirm that particular process, to say the legislation does not indicate how this should be done. If the Chief Electoral Officer feels that information will come staggered, as long as the requirements of Section 15 for registration have been satisfied, that would still be in line with the legislation.
Absolutely. I mean, of course, this was a truncated judgment, but there was so much substance to it. And in case our viewer has missed what was said, I just want to take you back just over an hour ago now in the High Court in Johannesburg when they made this pronouncement dismissing the ANC's application for the IEC to deregister the Umkhonto party. This ruling was delivered by Judge Lebogang Modiba. Let's listen in.
The following order is made. The application is dismissed with no order as to cost. As to costs. We hand down judgment.
All right, so just taking you back to that moment in those few seconds. But back to our discussion, Tate Terry Tselane. From your vantage point and given your own experience, does this mark the end of the issue, do you think?
I think the judgment was very solid in every respect. And I think, well, I doubt that the ANC would want to take this to the Constitutional Court as the court of last instance. I suspect that they're going to abandon this in terms of the taking the matter to the Constitutional Court, and that they will rather pursue now the matter that is before the High Court on the trademark and a patent of MK. And I think that's where, in fact, they're supposed to have started, is to have actually gone to the Electoral Court, because they had absolutely no chance in terms of winning this particular one.
You know, part of what the court had said is that, well, let me take a few steps back. In their argument, the ANC, in part, said that the Electoral Act doesn't make any pronouncement around supplemented applications, and they kind of latched onto that as a reason to why the MK party should be deregistered. If that is true, and Terry Tselane, is it time perhaps for the Electoral Act to make some kind of pronouncement, given the lessons that we've learned around this particular litigation?
No, I think the Electoral Act is okay in terms of the way it's actually structured, because to begin to venture into that particular area is begin to really deal with the detail of how an application of law should actually happen. And I think the fact that it is left to the discretion of the Chief Electoral Officer in terms of how to comply with Section 15 of the Electoral Commission Act, I think it is sufficient, and there is no need to review the legislation in order to put those kind of details. If, in terms of the law, the requirement is that you've got to submit a deed of foundation, you've got to submit the Constitution and the signatures of 1,000 people as it was requirement by them, and then you submit this information in a staggered way, it does not really defeat the purpose and the object of Section 15 of the Electoral Act and Electoral Commission Act. And I think it was proper that the judges eventually came to the conclusion that there was nothing wrong or untoward in terms of implementing that section in this case.
Yeah, especially when you consider, of course, that the MK party wasn't the only organization that essentially was registered using a supplemented application. So in my mind, if this court found in favor of the ANC, they would have to kind of extrapolate the implication and essentially ask these other parties to also resubmit their applications, right?
Well, that would have been a risk, even though, remember that the courts, what they do, they deal with matters that are before them.
Right.
And therefore, they would not have said that all other political parties that had registered before should also follow the same process, even though it opened a window for any person who had actually registered to scrutinize how those particular parties were registered. But remember that at the beginning of the judgment, they also indicated a period within which you can object with the decision of the Chief Electoral Officer, Deputy Chief Electoral Officer to register a political party. Now, that would mean that any person who wants to follow that particular route would obviously be out of time because the registration of political party has long passed, and therefore the period within which objections were supposed to have been made has already passed, and there is whatever issue that we're going to be raised, we're still going to be dismissed by the court because they are out of time.
Yeah. I mean, you've had a whole lot of experience in running elections, Terry Tselane, and I wonder to what extent you reckon this has been unprecedented. I mean, often we say a lot is at stake with this election for a whole host of reasons. I mean, the way people vote is going to be different. There's an unprecedented number of people contesting the polls as well. But it also feels like there's a whole lot more litigation at an earlier stage than we've seen in the past. What's your take insofar as that is concerned?
Well, there is an atmosphere of nervousness and anxiety in our society in terms of preparations for these elections. And I think increasingly there are quite a number of people who are going to be raising issues going forward. And then I think what is also complicating matters is the fact that the legal framework has not as yet been finalized, as you may be aware, that there are certain aspects that relate to independence and what is commonly referred to as Electoral Matters Amendment Act or Amendment Bill that still has to be signed by the President. Now, to be managing the elections when the legal framework has not been finalized poses a challenge for the Commission. And I think it is possible that you are going to find more and more people beginning to challenge certain aspects in the midst of preparation of the elections.
Yeah, and this is precisely what you had warned even after the Constitutional Court sent this back to Parliament to make decisions in the lead up to the polls this year. Terry Tselane, thanks as always for making time to speak to us. Appreciate your insights. The first of many discussions between now and the 29th of May, I suspect. Terry Tselane is the chairperson of the Institute of Election Management Services in Africa. Once again, thanks very much indeed.